Hello friends, in the series on the income tax cases, today we will discuss the case of ASHOK, DEVICHAND, JAIN versus Union of India and others. This case has been reported in 452 ITR at page number 43. The matter has been decided by Bombay High Court and the date of the judgment is 8th March 2022. This case relates to the assessment year 12-13. The notice under section 148 has been issued by the assessing officer to the assessee. The assessee has filed the return of income for the assessment year 12-13 of an amount of rupees 64.34 lakh. There is an instruction of the Income Tax Department through Central Board of Direct Taxes, instruction number 1, dated 31st January 2011. According to that instruction, if the assessee lives in metro cities and if the income of the assessee is up to 20 lakh, then the jurisdiction to do the assessment is with the assessing officer, and if the income of the assessee is above 20 lakh, then the assessment should be done by the assistant commissioner or deputy commissioner as the case may be. When the notice was issued to the assessee objected to this notice on the ground of jurisdiction also, apart from other grounds. It was the submission of the assessee that this notice is invalid because it has been issued by the assessing officer and not by the assistant commissioner or deputy commissioner, so this notice is not valid. But the objections of the assessee were not accepted and the order against the objections of the assessee were passed. The assessee filed the writ petition against the notice and the order against the objections filed by the assessee. When the notice was issued to the department in the writ petition, the assessing officer admitted that this notice has been sent without jurisdiction, but the assessing officer also said that there was no time with the assessing officer to transfer the file to the deputy commissioner because for that the approval is needed, and there was no time with the assessing officer to first seek the approval and then transfer the file, so the assessing officer issued the notice. Now the moot question before the Bombay High Court was that whether this notice is valid in the eyes of the law. The Bombay High Court held that this notice should have been issued by the assistant commissioner or the deputy commissioner according to the instruction number 1 of 2011 dated 30th January 2011, and this notice is without jurisdiction. Delhi High Court also, by relying on this judgment, have issued the notice to the department on the same issue, and the name of the case is Suchi Agarwal versus Assistant Commissioner of Income Tax. So broadly we can say that the Bombay High Court and the Delhi High Court are on the consensus on the same issue. But the Allahabad High Court on the same matter has given a different judgment. The name of the case is Shiva Aditya Gems and Jewelry Private Limited versus Income Tax Officer. The date of the judgment is 14th July 2022. In that case, the Allahabad High Court held that the notice is valid and these monetary limits are only for the administrative purposes and they cannot render a notice invalid. So friends, on the same issue, there are now different opinions by different high courts. So we can say that, and we can take the chance by filing the writ petition that if the notice has been issued by the assessing officer while the jurisdiction is of the assistant commissioner or the deputy commissioner according to the instruction number 1 of 2011, then in that case Delhi High Court and the Bombay High Court has the same opinion, and the notice is not valid in the eyes of the law. At the end of this video, once again I am repeating the name of the case. The name of the case is ASHOK, Devichands, JAIN versus Union of India and others, and this matter has been reported in 452 ITR at page number 43, and the date of the judgment is 8th March 2022. Thank you, friends.